Good afternoon. This is Janice Strutt, the co-founder and executive director of Morgan's Caring Connection, and welcome to our empowerment session. Today we have Liam Gilhooly from LFG Legal, and he's going to be discussing what is a will versus a trust. I know that there's a lot of confusion around this. People think that, a will is all they need or whatever from a legal standpoint. And more times than not, it's not correct. So that's why we get people like the experts like Liam involved. So we make sure that we're guiding you in the right direction. So without further ado, I'm going to hand this over to Liam. We'll get started with the first question. And that is, what is the point of having a will?
Hello, everybody out there. My name is Liam Gilhooly, as Janice put it. I am the only attorney. I'm the owner at LFG Legal. So there I primarily do estate planning. So setting up documents like wills, trusts, powers of attorney, estate plans. And that's partly what we're going to discuss here today in the session is what is an estate plan? Because that's really the overarching question of this is what is involved with that process, because it's not just a will or a trust. While those documents are very important in setting up an estate plan, they're not the only documents. Now, those documents account for death, but what about disability? What happens if you can't make your own decisions and you don't have a document that's legally binding that transfers your authority to make decisions for yourself to your trusted family members and your loved ones? Then you run into a legal roadblock. So we're going to get into that. Thank you, Janice, for having me on.
Yeah, you bet. You bet. So back to the question is, what is the point of having a will?
Right. So the point of having a will, right, is, well, first of all, the will is a death document. Okay. So it really only comes into effect when somebody passes away. The probate court in Wisconsin requires that everybody file a will with the state when they pass away. And if they don't have a will, well, then all of their property is going to go through, I don't like to, put too much bad emphasis on this word, but probate, not a bad word. We don't have to be afraid of it. But probate is just a court process that gets your property distributed and retitled to those who it belongs to, right? So that process can take many years in some cases, even with a will. A lot of people think that a will is a way to avoid probate. Well, it's actually instructions to the probate court on what to do with your property. So it may make the probate process quicker and easier for the judge, your family, and the lawyers involved, but it'll still be a very lengthy, public, and costly process.
Okay.
So yeah, a will is just that. It is a piece of an estate plan. It is not the entire estate plan. Sorry, go on. Jumping the gun a little bit.
No, that's okay. Yeah, like tell me a little bit more about what does it do? Maybe a little bit about how much something like an average will costs.
Yeah, so yeah, a will just is, like I said, it's an instruction to the probate court, and it gets your property from your dead hands, because remember, this is once you passed away, from the dead person to the people who you wanted it to go to while you're alive. And usually a will by itself, I mean, I don't like to do, just the will document, because that is like I said, a smaller piece of a bigger estate plan that should be in order, to account for, life's unexpected turns. But typically a will plan is for a married couple is in the neighborhood of $1,750. And for an individual, around $1,000.
Okay.
So that would include, that's not just the will though, that would include the healthcare and financial powers of attorney. Sorry to cut you off.
No, that's okay.
The HIPAA authorization, the authorization for final disposition, which is, the document that gives the authority to a trusted family member to make decisions at the funeral home. There's all sorts of documents that come included with the will plan that really gets your estate moving and makes sure that your family members or yourself don't run into any unwanted roadblocks along the process.
Okay, so a will is not an estate plan, is what you're saying.
Correct.
Okay.
It is a part of an estate plan, just like a trust, but it is not the entire estate plan.
Is there a place and a position that a will does make sense for people?
Oh yeah, yeah. Especially with smaller estates, or maybe if an estate is primarily made up of, one asset, a real property asset like a house,
Okay.
then it could make sense to have a will because, probates will only trigger if formal probates, that is, um, in Wisconsin, if your estate going into the probate is above $50,000. Okay, so a
Okay.
way to get around that is to set up beneficiary designations, transfer on death deeds, payable on death accounts. Those things get the assets out of your estate when you pass away and before your estate gets to probate. So if you, for example, if you have, a $300,000 home and your estate is totally worth $320,000 and you have a transfer on death deed attached to your home, well then that that transfer on death deed kicks in when you pass away when your heirs present a death certificate. So that means that your estate will be less than $50,000 avoiding probate. And, for just using a will, then the will can help to clean up the rest of those assets without probate.
Got it. Okay. Yeah, it's kind of thick as mud. Um,
There's a lot of moving parts, but
absolutely, absolutely. I know a lot of people when they come to me, and they say a will, I kind of cringe just a little bit, especially with families with special needs dependents, because in that case, a will certainly is not, I would think, again, I'm not an attorney. Would you recommend just a will for somebody that has a special needs dependent, I guess is the question.
it's case by case really, but you know, the biggest struggle with families who have special needs dependents that they run into is when, distributions are made to their heirs, including the special needs dependent, that distribution can kick that well, I shouldn't say kick them off, but they can put them above that distribution can put them above the asset threshold needed to qualify for their government benefits like Medicaid and SSI. So if they're receiving medical care that they're relying on, then they could be removed from that until they qualify again, having to find another way to pay for that, usually through private pay until
Right.
it's kind of drifted down again. And that's not the best scenario. So what you can do to avoid that is you could create a special needs trust while you're alive, in the name of for the benefit of your special needs dependent. And then when you want to give them money, or if you pass away and leave them money in inheritance, then what would happen is that money would go to the special needs trust, which is different than the individual receiving it in their name.
Right. And
So,
we'll save all that for another video,
right,
but
I'm getting ahead of
really, like, I get it, but a lot of people don't. And when we first started the process, we didn't get it either. And so I kind of cringe a little bit sometimes, want to make sure that, grandma who thinks they're doing a favor by leaving an inheritance to somebody, and they do it very well, good-heartedly and in great intention, but then it ultimately can financially devastate them. However, I want to say that kind of lightly because I believe that it's not the end all be all. There are things that can be done, but you got to remember that this is a special needs dependent. And if they don't know how to navigate through that, then yes, that potentially could ultimately financially devastate them, not help them.
Yes.
So that's why I want to make sure that people understand the difference. So why don't we go into how a trust is different from a will?
Right. So, I mean, a good way to think about the difference between a trust and a will is, a will is a document that's presented to a public court, probate court. Now, the trust is a whole private affair. So you're keeping it privately held, privately distributed, not through the court system. It's almost like a big beneficiary designation with a lot more elaboration to it. Um, so there's a lot more that can be done with a trust than a will, because you don't have that court oversight dictating everything and, making sure that, there's a new court appearance made for every new subject. So that can be really a large part of the drudgery that goes along with will planning is, having to go through having to go through a probate court every single time to get things done. But with a trust, what you do is you set this revocable living trust up or irrevocable living trust, depending on what your goals are, during your lifetime. And that trust will Wisconsin allows trust plans to avoid the probate process because they are methods of distribution, methods of retitling, which is what the probate process is ultimately designed to do. So, what you would do is you could have your revocable living trust. You and your spouse would be the trustees. You would be the grantors, the people making the trust, and you would be the beneficiaries during your lifetime. And you can appoint a successor trustee to kind of help administer your estate like a personal representative to where it ultimately belongs to, not having to deal with the whole court process and not having to pay hourly attorney fees the whole way through.
Right. Well, a couple of things that I try to explain to families is that when people ask how much does it cost? Okay, well, we could kind of gauge that, but there's different scenarios. So for example, there are more blended families probably than ever. So, you might have a situation like what we had where we weren't married when we did our trust, so therefore they were individual, they were not a joint trust. We had two biological children for one and one biological for the other. So we mixed up the ratios of distribution of funds.
Mhm.
I've also heard that if a couple is married and they don't have their finances together, that's yet another way that things sometimes, change. The other thing too is one of the families that we've worked with recently, the mom is the biological parent of her daughter. Then she's married, but he's not the biological father of her, but then they had a daughter together. So, like I try to explain to people that it's not a one size fit all. And one of the nice things about the trust is you pretty much can do whatever you want to make it
Yeah.
exactly what you want, including funeral arrangements or your wishes around what happens upon your death. And I mean, it's a lot of information, and I try to prepare people that you're forced to make a lot of uncomfortable decisions. But the great thing is when it's done, I mean, I don't want to say it's done, like finished, because things change. You
Mhm.
might have younger kids that go, get older. And so it's a breathing, living document in that you have to continuously revisit it. But at the same token, a majority of things then are finalized and done. So it can be a huge relief, sigh of relief to know that things like that have been taken care of and decisions have been made. So again, I know that you can't say exactly, but typically what's arranged for a trust to cost?
So a trust plan, a revocable living trust plan, because remember, there are many types of trusts designed for all different types of purposes. But for the revocable living trust, whose primary function is to avoid probate and manage family assets and make sure that they aren't mismanaged, essentially, provide security for the beneficiaries and asset protection. That plan is normally around $4,000.
Okay.
So that can vary depending on the family's circumstances. It can go lower, it can go higher, but that's probably the average price of a revocable living trust plan.
Okay. Well, it makes sense. And a lot of people, again, it's kind of like sticker shock. And I'm one of those that I go, okay, if I'm 40 when I do my trust and I live to be 85, that's 45 years that I can that I can break that $4,000 to, which
Yeah,
really is pennies. So
yeah.
Again, although it's a lot of money right in the moment, I mean, we don't think twice about buying ourselves maybe a new mattress or a nice car or, whatever. And then we go, oh, well, oh, trust, that's really super expensive. My estate plan, that's really expensive. I don't know. It protects everybody. It's
Right.
something that takes the burden off of the people that you leave behind to make decisions. So can you put a price on that?
Yeah, and it is hard to actually, put a price on that because behind that is many years of education and expertise
Right,
going in to build the trust, first of all. And on top of that, many other areas of the law, including estate planning in some cases, you're encountering hourly fees rather than flat fees.
right.
So I actually consider that a nice benefit of working with estate planning attorneys is you actually know what you're getting into. There's no hide the ball. There's no hourly fees that you don't want to, you didn't think you were going to pay, but you actually do have to pay. And so it's very clear and concise what the payment structure is. And at LFG Legal, I like to offer a free consultation, just so that, prospective clients can get an understanding of what they're getting into, the benefits of estate planning, the benefits of trust and will planning before they actually make a decision, So that is, once they decide to commit, and once they decide that this is what they want to do, then we can decide exactly what the plan will look like. And from there, we can, get a price into their laps and make a decision about that.
Absolutely. So I guess the burning question that people really want to know, and I kind of have an idea because you can't say definitively, but what's the average timeline that it takes to put an estate plan in place?
So yeah, the average timeline, it does vary, like you said, and I'm sure it is a burning question for all you out there. It's normally around 1 to 2 months. Just to cut it short here. It is normally around 1 to 2 months, but that really varies depending on both parties' schedules. How soon can the estate planning attorney meet? How soon after the decision is made to kind of go down this pathway can the clients meet? And how often can they meet? It's typically broken into three meetings. So there's an initial introductory meeting. I usually like to keep that educational and get a greater sense of the picture of what their goals are and what their interests may be in getting their estate plan done. And then there's a second meeting where that meeting is a lot more information oriented, a lot more informational exchange oriented, where the client will have shared with me a lot of their goals and their asset makeup and their family information, so I can come to a decision to present them various plans that might align with those goals and assets and all that. And then the third meeting, ideally, it doesn't always get done in three, but usually it does. That will ideally be where the attorney will go to or the client will go to the attorney or vice versa, whichever it is. The signing will happen of the documents and the estate plan will be finalized. And of course, there's another piece of this where, especially with a trust is just a piece of paper without assets being named inside of it. So if you have a trust and your home, for example, isn't inside of it, well, then your home is still going to go through probate because it's not titled into the name of the trust. It's still in your individual name. The same is true for checking and savings accounts. And for retirement accounts, beneficiary designations need to be on those to name either your spouse or your trust as second, so that when the second of you passes away, it'll go through your trust and hopefully to your beneficiaries ultimately.
So basically what you're saying is once the actual trust is done, there's still some homework to be done.
Exactly. Exactly. It doesn't end there.
Yeah, absolutely. Well, I think that this is a great place to start for people. I look forward to our next session where we talk about what is an estate planner,
Mhm.
or estate planning attorney. And I think a lot of people are under a lot of misconceptions, and why they should work with one versus, say, a general practice attorney and stuff. So I'm looking forward to that. And I think that's it. Is there anything else that you wanted to cover?
I think we hit on the very high end topics there. Keeping it at the sky level there. So that seems to be good for now. I appreciate your time, and I'm always happy to talk about estate planning. So thank you
Thank
very
you very
much.
much for your time and your expertise, and I look forward to our next session.
Thanks, Janice.